afternoon, ladies and gentlemen. It's our great pleasure to have such prominent panelists here. Before I introduce them formally, please take a note. The view expressed here by the panelists in the session are their personal views only and should not be attributed to their organization. The information provided should not be relied upon for business purpose or taking into consideration legal advice. The Heavner, of course, practice trademarks, intellectual property related issues, TTAB, everything. He has many prestigious clients. He's obtained exclusive ex parte research procedures, counterfeit goods, copyright infringement in cases of individual counterfeits involving counterfeit pharmaceutical, pipe coupling materials, illegal copying through computer hacking as well. And Garrett has been invited globally for many trademarks related seminars, such as Danish Patent and Trade Office, and FDA and US, Patent Trademark Institution of Canada, UK, and LES Taipei. He has been recognized as a legal 500 US for copyright litigation and for trademark prosecution and non-contentious work.
My topic is going to be following up on what Dermot said earlier. As you go through the U.S. application process, you get to a spot where your application is published for opposition, and it's published before in the official gazette of the U.S. Patent and Trademark Office. And once it's open for opposition, people can object on various grounds, and they object before what's called the Trademark Trial and Appeal Board, the TTAB. So, first question: what is the Trademark Trial and Appeal Board? Well, it's an administrative court made up of administrative law judges. They are a panel usually of 3 judges that make the decision as to whether or not the oppositions or cancellations should be sustained. And it is part of the U.S. Patent and Trademark Office. So what are oppositions and cancellations? Well, they are a special kind of litigation. It's still really a litigation type framework. And why do people file them? Well, the idea is they want to stop someone from either obtaining a registration to which they are not entitled, or maintaining a registration that is somehow improper and they're not entitled. They can also use this to try to help get rid of blocking applications or registrations that were filed earlier, but for various reasons you believe you ought to be able to get around. We're going to talk about that as well. So what does the TTAB decide? The only thing the TTAB decides is whether or not someone is entitled to obtain or maintain a registration. What they don't decide is whether or not you can continue to use the mark. Or if you've got a problem with the mark that you think is an infringement and you want someone to stop using it, you're going to have to go to a regular federal district court in order to get some sort of injunctive relief. The TTAB has no power to order someone to stop using the mark. Okay? It also has no power for damages. So you can't get any damages or get any sort of payment before the Trademark Trial and Appeal Board. And the Trademark Trial and Appeal Board also has no power to require someone to disclaim or somehow change or alter their trademark. The only thing they're going to decide is whether or not you're entitled to your registration. So what does this kind of litigation structure look like for the Trademark Trial and Appeal Board? Well, it in some respects mirrors a regular U.S. litigation. That you've got something like a complaint, you've got something like an answer, and you have a period. It's kind of like discovery. Actually, it is discovery, so you can use all the tools of discovery that are normal in a U.S. court. The main difference, however, is when you get to trial, there's no live trial like you'd see on television or you're used to, where you'd have witnesses or a jury or anything like that. It's basically done on paper. So you're submitting through something called a notice of reliance, the documentation that you're going to rely on. For witness testimony, it's usually done by affidavit. If there's any sort of cross-examination of that witness, all you're doing is submitting a transcript of what that is. And then the judges in the Trademark Trial and Appeal Board will review all of that and make their decision. There is an option for oral argument at the end. That would be the only sort of live activity, but that is optional. The Trademark Trial and Appeal Board does not require you to make the oral argument, and sometimes parties decide they don't want to do that. They just rely on the papers. So that's what the process is. All right, so as Dermot mentioned, there's lots of different grounds that you can raise for your oppositions or your cancellations. So let's talk about some of the most common ones. The most common one, obviously, is likelihood of confusion. That is that you believe that the application or the prior registered mark is likely to be confused with your mark, to which you have some sort of prior rights, either a prior registration or prior common law rights. So, how do you prove likelihood of confusion? Well, the U.S. Patent and Trademark Office has a test. It's called the DuPont test, and it has a large number of factors. I think there's something like 13 factors if you look at each one of them. So I'm going to talk about kind of just the main ones here. The first is the strength of the prior mark, the mark that's being asserted. That is, is it something that's kind of descriptive, almost descriptive, or so highly suggestive that it's weak, or is it a diluted mark because there's a lot of other similar marks that kind of coexist in the same field? They will look at that as one of the factors. Then they're going to look at the degree of similarity between the two marks at issue. Do they sound alike? Do they have the same meaning? Do they look alike? If there's a graphical element, how similar are the graphical elements? Then the next factor that the TTAB will look at is the similarity in the goods and services. Are they competing goods and services, or are they like complementary goods and services that would be used together, or are they services that are so related that even though they're not used together, people might think they come from the same source. They'll look and see if there's overlapping purchasers, overlapping channels of trade. They will look at how sophisticated the consumers are. And there's a couple of different ways you can do that. Usually it relates to the use issue that Dermot mentioned earlier. Either bona fide intention to use or use. So let's talk about bona fide intention to use. In the US, all applicants, except for ones that are under 1A for use, must allege they have a bona fide intention to use the mark in commerce on all of the goods and services that are listed in their application. And that's true even if you're filing in the Paris Convention or in the Madrid Protocol. A lot of Madrid Protocol people don't realize that when they click that box, it includes something swearing under oath that they have a bona fide intention to use the mark. Well, if you actually don't have a bona fide intention to use the mark on everything that you've got listed there, then your application can be considered void, either in whole or in part, and any registration that followed from that application can be canceled. So let's look at some example. Well, first we'll talk about what is a bona fide intention to use. I guess that's kind of the definitional question. And under US law, it means basically you're not warehousing the mark. You're not trying to simply reserve it, but you have some real objective evidence, real objective grounds for saying you're going to be entering the US marketplace. So let's look at a good case. This is Honda versus Frederick Winckelmann. So poor Mr. Winckelmann, he made seat covers and steering wheel covers. And so he tried to get a registration for his mark, VIC, in the United States, but instead of listing his goods and services as seat covers and steering wheel covers, he listed it for vehicles for transportation on land, air, or water. And he based it on his EU registration. Honda was not very happy about that because they thought the way he depicted VIC looked like their civic mark. Not probably the greatest case for likelihood of confusion, but they were lucky in that they hit upon the fact that Mr. Winckelmann had never actually made an automobile. Okay? He didn't have the skill to make it, he didn't own a factory, he'd never made any sort of automobile ever, he had no business plan showing he was going to somehow create automobiles, or much less boats or aircraft or anything like that. So during discovery, they determined that he had no business plans or anything. And so Honda amended their opposition to say that he lacked bona fide intention to use the goods and services. And the Trademark Trial Appeal Board agreed with that and sustained the opposition, holding basically, you've got to have some evidence that you have a plan to enter the U.S. market, and the absence of having some objective evidence suggests that there's no bona fide intention to use the mark. And you've got to have an ability to actually make what you said you were going to make, which he didn't. So poor Mr. Winckelmann lost his application. So kind of a practice pointer here. In the US, there are a lot of warning flags that kind of come up on the bona fide intention to use the mark. And I personally love seeing these warning flags because I will always add a failure to have a bona fide intention to use the mark whenever I'm opposing an application that meets this criteria. So one is like having a long laundry list of unrelated goods and services. I mean, I just love it when I see a Madrid application that's got like 200 products ranging from like lawn chairs, teacups, shampoo, you know, computer software. You see that sort of stuff all the time. Yeah, it's crazy. But yeah, I'm sure you're able to make all of those things. So when I see that, I instantly have a failure of bona fide intent. Or class headings. My particular favorite is like class 9 headings, you know, navigational equipment. You know, you find out they make eyeglasses, but why do they have navigational equipment in there? So you can use those sorts of things to support a lack of bona fide intention to use. So now, another thing is the use-based 1A application. A lot of people like to have 1A applications because they're actually cheaper. If you actually have some use, you don't have to go through that allowance phase that German talked about. A lot of people do file them. But it's very, very important that you don't inaccurately claim that you're using the mark on all the goods and services when you're not. And a good case is the Kucher versus Platum case that came up a couple of years ago. Kucher filed an application for the mark Platum, claiming that they were using it on writing and production services for motion picture, film, television, and new media. And their specimen was a printout of their website, which advertised those services. Well, Disney, the big bad wolf Disney, was upset about this because Disney wanted to use Kucher also, and they were blocked by Platum. And during discovery, they found out that Kucher actually, when it filed the application, did not have the facilities, did not have the ability to actually do that sort of film production, television production work. They were just kind of promoting it on the website, kind of in a pre-launch kind of way. So Disney petitioned to cancel. And Kucher argued, hey, look, you know, we're using the mark. It's advertising, it's e-commerce, people can see it, it relates to what we said we're going to do. That's good enough. Well, the Trademark Channel Appeal Board said, nope, that is not good enough. In order for you to have a 1A use-based application, you have to actually be rendering those services in commerce, and merely advertising it is not going to get you there. All right, and the last thing we're going to talk about is that the TTAB decisions actually can turn out to be very important, critical decisions, and you should not take them lightly. You know, years ago, because the TTAB only decided registration, and in theory, people thought if I later on get into an infringement suit, the US district courts are going to kind of decide this again anyway, I can kind of be cheap, not really pay a lot of attention to the TTAB, and not worry about it. Well, along came the Supreme Court decision of B&B Hardware versus Hargis. B&B had opposed Hargis, alleging a likelihood of confusion. They were dealing with the seal-type mark, both of them seal-type. The TTAB found that there was a likelihood of confusion. Hargis decided not to appeal. They decided not to worry about it. And later on, B&B sued Hargis for trademark infringement. And B&B argued that, you know, hey, the new federal court is bound by what the TTAB decided on this likelihood of confusion issue. The other side, of course, said, well, you know, they shouldn't be binding. TTAB is not an Article III court, and the court should be free to come up with a different conclusion. The jury found for Hargis. They found the opposite of the TTAB. B&B appealed, and the Supreme Court said, you know, wait a minute, we're going to reverse this, because the TTAB looked at exactly the same evidence, exactly the same issues. There was no new issue before the jury, and so it was wrong to even get to jury, and that the court was bound by the TTAB's decision. So that kind of makes it a little bit scary. In some respects, you've got to really pay close attention to what the TTAB says, and you can't really take these cases that way.